Good afternoon, everyone. Allison Scoberg here, Consolidated Planning Group. We are excited to be back with you. If you're joining us again, if you're here for the first time, welcome. We are so glad that you are here. So today we are talking about, do I need guardianship? And I want to preface this meeting today. If you're attending from out of state, you are absolutely welcome to be here. I know that we serve families all across the United States, but today we're kind of talking about the laws of Texas and guardianship and alternatives to guardianship surrounding the laws and how they read in Texas. And different states have different laws as it relates to guardianship. Sometimes they call it conservatorship, sometimes they have supported decision making, sometimes they don't. So I just wanted to mention that because I don't want to be having somebody go down the wrong track if they're not in this particular state. So thank you for taking the time to be here with us today. If you're planning your day, this will be an hour or less, so we will be done during that time. Today's webinar is being recorded. We are in webinar mode, which means that we can't see you or hear you. Sometimes people are listening to this on podcast. Everybody that's attending today will get a copy of today's slides and a link to the recording. And if you happen to be listening to this on podcast and would like a link to the slides, you can email us at contact@cpgcares.net. That's contact@cpgcares.net. We'll be happy to provide you a slide. The slide deck. All of our past webinars live on the Consolidated Planning Group YouTube channel. That is out there where you can subscribe to for free. So if you're a professional serving families that have a loved one with a disability, or you yourself or a parent, so please feel free to share that YouTube channel. There's over 400 webinars on planning for special needs. If you can think of a topic, it is probably out there. So do check that out. Consolidated Planning Group, we are a holistic special needs financial planning firm. We're nationally certified as Social Security advisors and members of the Special Needs Planning Academy. So I always just, in the beginning, this is not the slides that we're doing today, but Melissa and I talk about the differences of what we do and what she does. So we're here today with Melissa Donovan from the Texas Trust Law Firm in Austin, and she's going to be talking to us about guardianship. But oftentimes we get legal questions, or we get people calling us saying that they want to set up a special needs trust or that they need to set up guardianship. And I know that you get a lot of calls for things that we do. So when it comes to planning for special needs, the very, very first thing that a person needs to know is that there are two different there's a team of people that you need to work with when you're planning for a loved one with a disability. And I liken they're the paper and we're the money. So they really don't do what we do, and we don't really do what they do. So the paper, the legal documents, those things like wills and special needs trust and guardianship, and she's going to talk about these things. That's what an attorney or an estate planning attorney does. And what we do is how much money do we need to fund that special needs trust? How do we retire, stay retired, make sure that we have enough money to fund that special needs trust after we're gone? And we also make sure that families keep their loved one eligible for state and federally funded programs. And that's going to be very, very important as well. So having said that, I want to dive right into this big question here of, do I need guardianship? Because I know that's a big personal decision, and it's a big struggle for a lot of families. We've got a lot of families that are afraid of what happens if they do have guardianship. They're also afraid of taking their kids' rights away. And then we have we have families that have kids that are on the line, maybe questionable. So I know that you're going to get into all of that today, Melissa, but tell us a little bit about the Texas Trust law, and let's get into it.
Well, good afternoon, everyone. As Allison said, my name is Melissa. I'm an elder law attorney here at Texas Trust Law. We are an estate planning, special needs, probate, and trust administration firm. Yes, primarily here in Austin. You'll notice in the chat I've given you all of my information, and you'll notice it says Austin and Georgetown. I am actually now in our Georgetown office several days a week, as well as a regular office. So for those of you who might be a little bit further north and don't want to come to Austin, we got that location too. But what we do here and what I do here is primarily focus on helping individuals who have either children or parents or themselves have some kind of a special need. So that entails, yes, like Allison said, some special needs trust planning, guardianship law, and also on the older side of things, more long-term care Medicaid planning. So it's kind of spans a whole realm of time. And this primarily is going to focus on more of talking about your children. There are certainly situations where we can run into guardianship concerns for elderly parents or siblings or so on and so forth. We will give you a little bit of information on that towards the end, but this was going to primarily focus on as your kids are aging up and what we need to get done for that. And if you do or do not need a guardianship, many times we can kind of avoid that, and most practitioners are going to want you to do that as much as you want to avoid doing that. So hopefully everybody will learn a lot as we go through today. And Allison's going to be manning the chat throughout the conversation today. So if you do have questions, feel free to post them there. I always like to preface those questions where I will ask you to try to avoid getting too personal. You are in a group of potentially hundreds of people here, so you want to keep things as general as possible, and also be aware that anything that is said today, this is meant to be educational in nature. If you need legal advice personally, you really need to sit down with an attorney directly, face to face, one-on-one. But let's kind of dive in here and figure out what's this guardianship thing about. So my guess is that most of you are here today because either you have a child who has some special needs and they're about to be turning 18, or maybe they're, 14, 15, and you're going, what do I need to get prepared for down the road? And probably have some practitioners, maybe a financial advisor, CPAs, whatnot, teachers that you just want to learn a little bit of information. So the biggest question is kind of, what is guardianship? And I get a lot of people, whether in talking in public or clients that come in, who, in my experience, tend to ask the question, my child has special needs, they're autistic, they've got Down syndrome, whatever that situation might be. And the initial statement is, well, we need to get a guardianship when they turn 18. And I always like to be very careful on that, because not everyone needs guardianship. And most practitioners, and whether people believe it from things you see on Netflix or not, most courts want to avoid guardianship as much as you can. Guardianship is you taking over the rights of the person that you're getting guardianship of. So there's various types of guardianship we're going to get into, but the heart of getting guardianship over someone is that you have complete control over the decision making for them, whether that be in the capacity of medical and health situations and living situations, or whether that be in terms of managing their assets and finances for them. We're going to talk about that a little bit more as we keep going. But there are what we refer to as lesser restrictive alternatives that we're also going to get into. Allison had mentioned something called a supported decision-making agreement earlier, and we'll kind of get into that because, like I said, not everyone needs to have a guardianship in place just because we have a child who's about to turn 18 and maybe still needs some support. So we're going to talk through that a little bit today. But when it comes to raising a child with special needs, like Allison was saying, there's a team involved. It's not ever going to be a one-man shop. You've got to have a different experience for different people. Like Allison said, she knows the money. If I have a client that comes to me and says, well, how much money do I need to put into this special needs trust that we're doing for our child? I'm going to defer to Allison because that's what they do best. They manage the money best. And my job is to tell you, these are the types of trusts available, or these are the provisions that we need. Maybe we need this in place in terms of documentation. Maybe we need a guardianship. Maybe we can do a supported decision-making agreement. But when it comes to alternatives to guardianship, there's a few things that we want to think about. And the biggest question is, what level of capacity understanding does my child have as they're getting into that kind of 17 age range? So, do we think that they would understand enough to be able to sign something like a power of attorney and giving you, or whoever they would like to, the authority to make medical decisions if they need someone to help them manage their money? Can we sign a supported decision-making agreement where you don't necessarily get to make the decision for your child, but you get to continue guiding them? In some ways, guardianship, I like to refer to it when we're talking about a specific type of guardianship, a guardian of the person. I like to kind of refer to that as being like, you get to continue being mom or dad the same way you have been. But then there's also guardians of the estate, which is a completely different side of things. So we need to look at the big picture in all of these things as we're having that conversation about, what do I need to have in place for my child as they kind of near that 18 birthday.
One thing, Melissa, and I'm gonna let you continue on your slides, but one thing that I want you to address today before we end today is what if I really should have guardianship in place and I really don't? And I think one of the things that I think about, I don't want to say the word worry, but it does cause concerns for me, is when there's a lesser restrictive alternative in place, but the person is borderline capacity or may not really may lack capacity. Maybe they don't drive, maybe they can't handle business or money themselves. If something happened to mom and dad today, they would be in trouble. They cannot live alone. Those are questions that I have that I want you to address, because I think I know here the least restrictive, most appropriate, and I agree with that, but I think there's been some extremes one way or the other that may not be right for that individual. So I want you to address that, okay?
So we'll probably kind of talk through that a little bit more as we go through, but there are going to be different responses to that depending upon what age group we're talking about. But let's kind of look at this here. Why might we need a guardianship versus a lesser restrictive alternative? And honestly, the key difference between these less restrictive alternatives versus guardianship is the level of control that you have as the guardian versus as a power of attorney or a supporter in a supported decision-making agreement. When you take and get guardianship over anyone, whether it is your child turning 18, or if let's say you have an older adult child that you just hadn't gotten guardianship for yet because you wanted to kind of see where things were going to go and you didn't want to do that right away, and maybe they're in their 20s now and things are not improving, you don't have to get guardianship at 18. I always like to be very clear on that. I have plenty of clients who, when their child turned 18, they wanted to put that step off. Realistically, they did need guardianship eventually, but you can go back and you can get guardianship later on in life. It's just that you want to be aware of what's going on with your child and what their needs are. And you want to be really understanding of the relationships that you and your child have with the professionals and the helpers, if you will, around them. What kind of relationships do you have with their doctors, the school? What kind of a help do they need? Is your child going to be in a work program? Can you speak with the other people that are going to need maybe some extra input that your child is not always going to be able to provide? And if we have a situation where we're kind of borderline, that's a conversation that I have with a lot of clients about, well, I always like to put it as are we going to go into this as a glass half full or a glass half empty? Because you can do it either way. Some parents want to go and get the guardianship to begin with, and if they absolutely need it, they need it. But truthfully, the way the law looks at things is that we need to be checking and we need to be really working to see if we do have some options with powers of attorney, with supported decision-making agreements. Like Allison had stated earlier, if you are not in Texas and you're with us today, just be aware that supported decision-making agreements are not something that are accepted in every state. So that might not be something available as an option in your state. But powers of attorney, medical, financial powers of attorney, HIPAA authorizations, those are things that you're going to have accessible in any state as an option, provided that your child has the understanding and the ability to actually sign those legal documents. So with some clients, what we are trying to do is see what works. And some people want to start as easily as possible. And if we have that level of capacity, that's what, as the lawyer, that's what we're going to want to do too. If you work with an attorney for guardianship, the thing that you need to be aware of is that that attorney does represent you. They don't technically represent your child in that process, but any attorney who does this work on a regular basis, who kind of specializes in it, there's a little bit of a deeper understanding that we do represent you and not your child. But if you have an attorney that's helping you with a guardianship, they represent you in working towards the best interest of your child. And many of you have probably heard that term before, but anything dealing with the court and dealing with a minor or an incapacitated individual is always going to be primarily focused on best interest of protecting that individual and balancing out that protection of them against the protection of their rights as an individual to be able to do things like make their own decisions about voting and medical decisions and where they live and where they work.
One thing I always mention to our clients is don't feel nervous to go meet with an attorney about this because their job is to do a lot of listening and to talk through. You don't have to go marching into the attorney's office with your hand on the desk of what you want. A lot of people don't know and they need a professional. They're seeking a professional to go through the options and guide your hand and what might be most appropriate for your loved one, and they're going to do a lot of listening. So I always just like to encourage people that people in your position, Melissa, other, estate planning attorneys and folks that focus on guardianship, that they're going to do a lot of talking and a lot of listening as to what are the capabilities of the individual, so that way they can direct you in the right direction. So I feel like people feel overwhelmed with this task of like, what if I don't know? you
We
know
don't expect you to. I don't think any attorney out there that's going to sit down with a client who has concerns or questions about guardianship or anything like that expects the client to have all the answers. That's why you come to us. We don't go to you. You're coming
right.
to us for expecting us to have all the answers. And truthfully, no attorney has all the answers about everything. But when it comes to these things, that's why you're coming to us. And it might sound silly, but I find myself saying this all the time, and not in every state, but in Texas, our licenses as attorneys say attorney and counselor at law. We use so much of that counseling side of things that half the time I feel like I'm more of a counselor than an attorney when you compare other types of the law. So you should be able, when you as a parent want to have these conversations, I know it's always daunting to see an attorney. Like nobody wants to go see an attorney. We all have these like law and order things in our mind about going to see an attorney. But people who practice in this area, generally speaking, are there because they really want to help your family and they want to help you understand. So I know we're not going to tell you that you can't be, you're going to feel how you feel and you're allowed to feel that way. But know that when you meet with that attorney, whoever it is, they're there to listen and they're there to guide. No attorney should expect you to know all the answers personally. But some things that you do want to kind of consider in advance. So first and foremost, you want to kind of know what exactly is the concern. How severe is your child's situation in terms of their ability to live on their own, make decisions for themselves? What is their post high school going to look like? All of these things you want to look at. If I have a child who technically does have a diagnosis of something, doesn't always mean that they actually need guardianship or further assistance than what you can offer as just being the parent of an 18-year-old. So that's the first thing, is knowing when you're talking to their doctors, when you're talking to their therapists, when you're talking to the people that they work with for whatever they are going through, the teachers at school, you want to get a feel for yourself of where you think your child is going to be at that 18 age point, because that is the magic number. No matter how much we all can probably agree, none of us were truly adults in the true sense of the word at 18. We all still needed our parents' help. Legally speaking, your child is an adult at 18. So all of the ability that you had prior to that birthday of talking to doctors, getting information, making appointments, making decisions for your child, that legally goes away. Now, the other part of that I oftentimes gets this question from clients is, well, if I don't have the guardianship in place right as soon as they turn 18, like, am I just cut off? And many times that's not what you're going to see happen with the regular individual. So like when you are talking about the primary care physician or the specialist that your child has been seeing for, a year, 2 years, 5 years, 10 years, generally speaking, those professionals are very used to these situations. And even if you don't have guardianship yet, or if you're in the process of getting guardianship, because the key is you're not going to have guardianship on your child's 18th birthday. Not in Texas. No court's going to issue that order on the 18th birthday. You're usually going to be at least a week beyond the birthday, and sometimes we're years beyond the 18th birthday. But in many situations, the regular people that you work with are going to continue to have open lines of communication with you, whether they legally should or should not. Not something that you want to count on. And that's where sometimes we do run into those situations. And maybe this is partially what Allison was getting at earlier too, where, we put it off, but then we run into a situation where now we need it and we need it quickly. Usually where these things come into place are emergency situations and dealing with those doctors that you don't normally deal with, which that can also lead to a temporary concern. There are also situations where people do need temporary guardianships to get through a particular situation because they don't have powers of attorney or whatnot in place. But you want to know what the resources are. So, like I said, teachers, doctors, therapists, all of the people that work with you and your child. And then you want to also make sure that you have a good understanding of what your child's abilities are. And, do you think, what does their day to day look like? What are the things they can do for themselves? What are the things they need help with? These are all things that your attorney is going to speak with you about when you go in to talk to them about this. And any decent attorney is going to go through this conversation with you in a lot of detail. We get really, really personal. I always tell clients right up front, we're going to ask a lot of personal questions. If you are uncomfortable, that might happen, but we need to get the information to be able to properly guide you in what's best for you and your family. Looked like you had a question there, Allison.
We got a couple of questions. One is more of a statement. The person said, my child is 23 years old, steps for an adult child. And I think that the clear message here is that the alternatives to guardianship or guardianship can happen anytime after 18. I mean, again, the process starts a little bit before 18, so it's pretty close to when they turn 18. But if you didn't do it then, you're not late to the party. You can still get things taken care of as you need to. So don't worry about that. If you've got a kid that's 23 or 26, they could be 46. If something needs to be in place, that is totally okay. And then another question, and this one comes up pretty regularly, in a divorce situation where there is shared legal custody, when the child is 17, do you need both parents filing together? Or does the custodial parent file for guardianship? How does that typically work here in Texas?
So I'm going to slightly go back to the last question in answering this question too,
Sure.
because in having this conversation today, I know we keep talking about, we have a child who's going to be turning 18. The guardianship that we're talking about, they are all adult guardianships. So all of these, whether you start the process at 17 and a half to get it at 18 or 24 or 42, they're all adult guardianships. The steps are going to be the same. Now, how restrictive you need to be, what type of guardianship you need to get, that can drastically change from 18 to 40. But when it comes to the divorce question, yeah, this is a question we get almost every single time. And the way that the courts work in Texas is that they will only appoint co-guardians if they are the still married parents of the child, the 18-year-old or adult child. So if there is a divorce situation, one of those parents is going to apply for guardianship. And hopefully, everybody's desire is that there's an agreement about who will do that. When you apply for guardianship, and we do kind of go through this process, if you want to jump to the next slide there. So this is different types of guardianship I was just mentioning. I mentioned briefly temporary guardianships, and then there's guardianship of the person and guardianship of the estate. This is where, going back to that, my child is 23, steps for adult versus the younger adults. Usually, if we are looking at, right at 18, we typically don't have assets yet. So we're just looking at a guardianship of the person. That's where I'm saying, basically your role as a guardian of the person is just to continue being the parent that you've been for the last 18 years. Guardian of the estate is where there's actually assets to manage as well. And usually we want to try to avoid that. And there are different ways to go about doing that. We'll kind of get into a little bit of that in a future slide here. But when it comes to guardian of the parent, that's where we are guardian of the person, that's where we are typically running into that question about, well, me and my ex, who gets to have guardianship? The primary objective before you start any of these processes, and I know it's not always the possibility depending upon how that divorce kind of worked itself out, but you want to try to have these conversations with the other parent as early on as possible to see if you can come to an agreement on this, because you will have one person that will get appointed by the court, but you need to be in agreement, because when you go through that process, there are people that have the right to be made aware and can contest it. So other biological or legal parent, adult siblings, those are people who always have to be notified, and we have to get them to be in agreement essentially. But only one of the parents will actually be appointed by the court in that situation of the divorce. Guardian of the person and the estate, you might end up in a situation where you need both. And that's where we have like those older children that maybe they did work a little bit before they ended up going under a guardianship, or like when we have parents who are still developing dementia or situations like that. Those are going to be a little bit different. They're going to be a little bit more complicated, a little bit more time consuming, and you're going to be much more involved with the court on those because you will have to have a guardian of the person and the guardian of the estate, which maybe are the same person, might be different people. It all depends on the circumstances in those cases.
Okay, one person said, I heard the other parent must sign the notarized statement saying I've told him I'm seeking guardianship. What if there is the parent that has been MIA for 15 years? And the next question that always comes up is, what if the other parent's out of the country? Those are the two questions that always come up.
So what the law requires is that certain parties, like I was saying, are notified. So either they have to be served. So when you think of like, if you watch TV and see like a constable go to someone's house with legal papers and, or they show up at the office and say, you've been served. You either have to do that or you have to get them to sign a waiver saying, I received a copy of the application. I'm good with this. You don't need to have, an officer come out to my house or my place of business and serve me with paperwork. So in those situations where we can't find someone, your attorney has to take best efforts to locate that person. Sometimes that involves hiring an investigator, but if you've done everything you can to locate and serve that person, your attorney is going to have to go to court for an additional hearing, but you can get by it if you've literally done everything the court is going to ask you to do to show that you made best efforts to notify that person. But if they are truly unreachable, it does happen sometimes. I mean, it happens in guardianship cases, it happens in probate cases a lot, and it's the same process and rules. If you've made best efforts, you've done what you can do.
Okay, a couple more questions and then we're going to move on. What if I remarried? Could I have my husband as co-guardian?
No.
Okay. And then, I just, since we're talking about the co-guardian for a second, so I know if you're like if it's mom and dad, then they can obviously be co-guardians, bio mom and dad. And does Texas do other co-guardians? Like for instance, if I had guardianship of one of my kids and I wanted my sister to be co-guardian, they don't do that. Is that right?
They don't. And part of this is the law, and part of it is process and protocols. So technically speaking, under the law, you can have co-guardians that are not just the parents still married of the individual. And there may be some counties in Texas that are different, but in every county that I work within here in the Central Texas area, the judges, generally speaking, will not appoint co-guardians unless they are a married couple, as specifically if they're a married couple, and then if they're not the parents. Sometimes what they will do, and this is more so for minors, but they will appoint grandparents as co-guardians. But in these situations, generally speaking, and truthfully, as an attorney and dealing with these situations and seeing the fallout of different types of setups, usually we're going to advise against co-decision makers anyway. It usually ends up being more of a problem than a problem solver in most situations.
Sure. We've got another question that comes up all the time, and from a financial perspective, I'm a fan of knowing so you can plan. Can you give us a range of a non-contested guardianship, about how long it takes and about how much? Just give us a range. Range is fine because Melissa is one attorney that works for one firm, and all attorneys set their prices differently. But prior to you answering, I just want to mention for anybody on here that are falling on hard times, there are legal aid societies. There's different organizations all across the state that help out with that. And then I know that guardianship is free if you live in Galveston County. There's a couple of other counties in Texas, not many. But Disability Rights Texas, there are some organizations that will help a family that has fallen on hard times. But give us a little range on that, Melissa.
So speaking as someone who works in the Central Texas area, I can say that generally speaking, for a guardianship that's not contested, fee wise, you're going to be looking probably between $4,000 and $10,000 when working with an attorney on this. And that does depend on whether it's a guardian of the person and the estate, just a guardian of the person. And of course, where you are and the attorney that you work with. Time frame is the really interesting one because technically speaking, you could get a guardianship in place if you're strictly looking at the actual context of the law. You could get it completed within 6 weeks. You generally are not going to. Most guardianships, even uncontested, are going to take 3 to 4 months. I have had some personally that even completely uncontested, seemingly pretty straightforward, have taken upwards of 6 or 7 months, just depending upon the people involved. And a lot of that, what I will say, so that you as the parents are aware of this, a lot of that has to do with being available, answering your phone when people called, making sure you're checking your emails on a regular basis because you're going to be having contact from other attorneys. And we're going to kind of get into that a little bit more about the whole process of things. But once you start this process, you want to know that you need to be fully involved in that process. So, you don't want to hire an attorney, file an application, and then you're ignoring your emails and you're not answering your phone or responding to voicemails. The more attentive that you are to those things personally, the quicker you're going to get things through, because there are going to be other attorneys contacting you, needing to meet with your children. And we've got some slides kind of walking through that too.
And we're going to continue on and we'll come back to questions in a little bit, but we want to get through the slides. And I think a lot of the slides are probably going to answer a lot of questions too.
So this slide kind of walks you through, and I'm not going to read all of this to you, but there's permanent guardianship. There is technically temporary guardianship. But the way that I like to kind of walk through and explain this is that no guardianship is truly permanent. When we refer to temporary guardianship, we are referring to more of an emergency situation where something happens very drastic, very quickly to an individual who they can't make the decision via power of attorney, and you are going to court, you are getting guardianship to deal with an emergency situation. When we're talking about a temporary guardianship, that's generally what we're talking about. When we're talking about full and partial guardianship, or permanent and temporary, permanent guardianship is meaning that we are applying for guardianship with the intention that we are going to need this in place, and I'm going to say for a while. The reason that I always say guardianship is never truly permanent is once you obtain guardianship, you have to renew that guardianship annually. So if you are doing guardianship of the person, there's forms that you need to fill out with the court annually to confirm that you still actually need the guardianship. And I tell my clients a lot, going back to that glass half full, glass half empty, things can improve, and you might have a child right now that needs this level of supervision, but maybe in 3, 4, 5, 10 years, they don't need that anymore. And we can go to lesser restrictive alternatives, and you can let the court know that at that time, and you can step back from the guardianship. It's never truly permanent. Now, many of them do last for the entire lifetime, but you have to renew that annually. Full versus partial has to do with how much you need to take over for that individual. So this kind of goes through a list of some of the things that as a guardian of the person, you would be responsible for. And as harsh as it sounds, that you're actually taking that right away from the individual that you're getting guardianship over. So, voting, licenses to drive, making decisions about work, healthcare, all of those things. When you have a full guardianship, that means you are taking over all of those things. We're not leaving any of those rights intact for that individual. Sometimes you can get away with allowing people to have certain of those rights. I've had cases where it's been very important for the individual and the attorney ad litem that works with them that they still maintain the right to vote in that election, and where everybody has been in agreement that that is perfectly acceptable. Or, maybe they can make some minimal decisions about things. So that is a very personal decision. And, different attorneys have different feelings on things, and different courts take things differently. But generally speaking, on a lot of these smaller things, courts will look at the individual. They always want to keep things as least restrictive as possible. So these are conversations that you need to be having with your attorneys when you're speaking with them, your advocates, and then the ad litem is going to have these decisions with you as well. And I know some of you are probably wondering what this term ad litem that I keep using is, but when you apply for guardianship, there's a whole process involved in that, and we're going to move through.
Can, Can you answer the question about, there's sometimes people think that if they have guardianship of their loved one, they're afraid maybe their loved one has some behavior issues or violent tendencies, maybe, harming tendencies or things like that. If you have a loved one under full guardianship and they commit a crime, does that make the parent responsible? I just want you to address that because I think that that's a myth in our community.
Yeah, it's interesting because I know we've gotten this question before in past webinars that we've done, but you are not responsible for, generally speaking, for the acts of the person that you have guardianship over, particularly dealing with that criminal question that Allison had just asked. Now, could you potentially be held responsible if something you did contributed to it? Yeah, but that's the case whether you're guardian or not. But you are not legally just kind of by default held responsible for things that I don't like the term, but sometimes we have to use it, that the ward, the person you have guardianship over, does. Now, there are reporting situations in place that now we have what's called JBCC here in Texas, which is essentially an overarching government agency that has all of the information about guardianships throughout the state. And so your police departments and the jails and things like that, technically speaking, do have access to information so that if someone does get arrested, there are things that in there that they can see so that appropriate people can be notified. But very long answer to the question, but no, as the guardian, you are generally speaking not going to be held personally liable or responsible for the actions of the ward. Now, could that change in the future? I mean, we are seeing situations now where parents are sometimes being held responsible for actions of their children. This is not how things are now. I'm not saying this has happened, but could that be a situation in the future if there's some neglect or whatnot on your part? Yes, that could come down the line. You do have obligations to protect the ward and keep them safe. But generally speaking, you are not going to be held responsible for those actions that the ward does take. So let's kind of get into the process and what this looks like in terms of the duties and what the process looks like. So as a guardian of the person, you are dealing with the individual's well-being, housing, food, shelter, medical care, jobs, etc. You have the right, if we have we're going to assume a full guardianship in this situation where we have taken over everything. So you have the right to possession and care and custody and control and all of that of the individual. That does not mean that necessarily the individual lives in your home. I get that question a lot, particularly from parents when we're actually looking at their estate planning and they have a child with special needs. That's where this question tends to come up a lot. If I name, my other child as guardian of my, special needs child, did they have to live in the home? No. And I know Alice and I have had this conversation in these webinars many times. We don't necessarily always recommend or typically recommend having a sibling as a guardian, but there are certainly situations where it works. I actually have a good friend myself who's been her sister's guardian for decades, and you couldn't take it away from her if you tried. But just because someone has guardianship, guardian of the person over someone, doesn't necessarily mean they live in their home. So you might have a child who lives in a group home. Or in another facility. And the guardian is strictly responsible for caretaking in terms of making sure that they are safe as an overarching goal. They also are there to make decisions in terms of medical, psychiatric, all of those things. There is an annual report. I think I saw this question in the chat as well, where someone had asked, is it $4,000 to $10,000 every year? No. Generally speaking, once you have the guardianship in place, you do not technically need an attorney moving forward. Sometimes there are situations where you might want to reach out to an attorney, but generally speaking, particularly dealing with guardian of the person only, if you have guardian of the estate, you are going to want to talk to an attorney in those reviews. But guardian of the person, if that's all that you have, and there was no need to get a guardian of the estate because we either didn't have any estate assets, so we didn't have large bank accounts or anything like that, or we had minimal accounts, then you can typically do that on your own. And it's a form that the court typically will send out to you about 60 days prior to renewal. Essentially, it's an anniversary, and every anniversary you have to fill out that form, submit it to the court, and get what we call letters. So you'll get letters of guardianship when you first get your application approved. And then every year you'll have to get new letters showing you are still the guardian for that following year. But that's a relatively straightforward report. It's in most counties, it's about 5 pages long, where you're just kind of letting the court know, how is our health? How is the ward's health doing? Have the situations improved? Have they gotten worse? Are they still living in the same place? That can also go to, do we need to transfer the guardianship? I think I had seen a question about that as well. If I live in Harris County right now and my child is in Harris County and I now have guardianship in Harris County, and then, we move to Williamson County, do I keep my Harris County guardianship? And the answer to that question is no. You're going to transfer that guardianship to Williamson County. But that process is generally a much shorter process. And it's just about moving essentially the case because Harris County no longer has what we call jurisdiction over your child. So dealing with guardian of the estate, and I said this earlier, is a lot more work, a lot more court involvement. And for most situations, something you're going to want to try to avoid. And depending upon the personal situation with the individual you're trying to get guardianship over, this can vary in terms of what options to try and avoid this are, or if there even are any. If we are dealing with trying to get guardianship over our, parent who has developed dementia and are, needing someone to really tell them what we need to do, then we're probably going to be looking at a guardian of the person and a guardian of the estate because they've lived their whole life. They have a home, they've got IRAs, they've got bank accounts. You're generally speaking going to be looking at a guardian of the estate there. But typically speaking, when we have young adults, so whether that's, our actual child who's 17 turning into adulthood or, our 20, 19, 24-year-old child, they haven't had a whole lot of time to build up a whole lot of assets. We can typically get away with not having a guardian of the estate. The reason why most attorneys are going to advise clients to try to avoid this realistically does come down to time and involvement of the court. Because when you have guardian of the estate, first and foremost, you need to post a bond. If you have guardian of the person, in most counties, you do also still have to post a bond, but that can be very small. So in some counties, that means it's just $100 of cash put down with the court. In other counties, like here in Travis County and a lot of your larger counties, they require a $13,000 surety bond, which does not mean that you are paying $13,000. It means that you are buying essentially an insurance policy to ensure the court that if something goes wrong, there's some cash there. Usually that's about like $300 and it's a one-time payment. So it's never a huge sum of money in the grand scheme of things, but it is some money you have to put up front. Versus if you have a guardian of the estate, they're going to look at the value of the estate, and then you need to post a surety bond based on a percentage of that value. And in some cases, a very high percentage of that value. So if we're dealing with $1 million estate, generally speaking, we're not going to have an individual as the guardian of the estate of that person. That's where you have professionals and things like that. That's why professionals take those things on, because it's a lot of liability and responsibility. When you do that, you have to file appraisals, you have to file claims, you have to file inventories with the court. Those are all things you don't get into when you're only needing to do a guardian of a person. So the ways that we avoid that is, one, if your child is 16 and you're considering this, make sure that your child is not going to have any bank accounts in their individual name when they turn 18. Okay. Now, they can have an ABLE account. That's a little different. You can set up that ABLE account as their guardian now and continue to manage that. But like, we don't want, Johnny graduates from high school and grandma, grandpa, auntie, uncle all give him a bunch of cash and we throw it into a checking account in his name. And now Johnny's got $30,000 in a bank account or $5,000 in a bank account or 500 even, truthfully speaking. Technically speaking, we have had a change in the law in the last few years here in Texas. So it used to be that if you had over $2,000 in assets that you had to get a guardian of the estate. They drastically increased that number up to 20,000 a few years ago. So that's a big sum of money for most people, especially if you're looking at an 18-year-old to have. But it's still, if you do that, you can have a guardian of the person now that is now allowed to manage up to $20,000, but it is going to increase what bond you need to post, and it's going to increase your reporting requirements. So generally speaking, if your child is 16, 15, 14, 13, 17, try to avoid getting a bunch of money into accounts that are going to be in their individual name, because it's going to help, especially if it's a very strong possibility that they're going to need guardianship. And even if it's not, go
We
ahead,
don't
Allison.
want that anyway because we
Yeah.
want them to stay Medicaid eligible, waiver eligible. I mean, there's a lot of reasons we don't want that to begin with. But one thing I did want to mention is some other states are very much pro guardianship of the estate. So this is a different viewpoint from Texas, and this is how it is in Texas. But some states, it's just kind of that's what they do: guardianship of the person, guardianship of the estate. They do it all at once, one big package, and so it's kind of a different take on it, but that $20,000 certainly does matter.
Yeah, it helps a lot because it's going to be a lot easier on you as the person who's trying to get guardianship if you don't need to do as much ongoing reporting. And truthfully, and maybe there are some people out there that disagree, but I think most people want to keep the court out of their life as much as they possibly can. And when you have a guardian of the person, yes, you have to do an annual report, and there are court staff that will want to meet up or check in annually with you, but you don't have to feel so much like I have to go to court to get permission to do everything. Where in a lot of cases with the guardian of the estate, you do have to check back in with the court and get permission for most things, and they have to approve budgets and things like that. So how do you actually get to the point of having that guardianship? The first step is talking to the doctors. So the first thing that you're going to need there's two ways that you can end up needing guardianship in the initial process. You're either going to be looking at getting a physician certification, or you're going to be looking at an intellectual disability report. The time frame on these things are slightly different. So if you're dealing with an individual that has an intellectual disability, that is the factor that's needing the guardianship. Technically speaking, you can have a determination of intellectual disability report that is as much as 24 months old as of the date of the hearing. So to give you an example, if let's say we have an individual who is turning 18 on January 1st of 2025, and typically speaking, we're not going to be looking at a hearing date on his birthday. So let's say that the hearing is going to be January 10th. Most courts require that it's about a week after the 18th birthday before, and just practically speaking. So let's say we have a hearing on January 10th of 2025. We can have a determination of intellectual disability report that is dated back to January 11th of 2023. Okay. Whereas if we are having a physician certificate, which is a 4-page document that your, primary care doctor for the individual or neurologist or whatever specialist is best suited to make this determination for your child based on their health situation, that can be filled out and signed up to 6 months essentially prior. So with that, or forgive me, it's a little bit less than 6 months. It's 120 days of the actual filing date, which is different. Okay. So you can have that done quite a bit before. Typically speaking, we advise clients that if you are looking at, you think you need a guardianship, you want to start that process about 6 months prior to the birthday. That's going to give you plenty of time to try to get that hearing as close to the 18th birthday as possible. Going back to what I was saying earlier, you can have a hearing from the application, 6 weeks to 2 months, but you want to be prepared for that longer time frame just in case. So usually if you start that process by going to the doctor, getting them to fill out that physician certificate about 6 months prior to the 18th birthday, you then are going to have to apply for the guardianship to the court. So if you're working with an attorney, you're going to hire your attorney. Your attorney is going to get all of that paperwork prepared for you. We're going to put in an application. And then once that occurs, two things are going to happen right after that application is submitted to the court. The court is going to have the constable's office serve your child, and an ad litem is going to be appointed for your child. Okay. So the only party in a guardianship suit that always has to be served by the constable's office is going to be the actual individual you're trying to get guardianship over, because you have essentially told the court they don't have the ability to sign anything waiving that right. The ad litem is an attorney that actually is there to represent your child. Going back to what I said earlier, the attorney you hire does not represent your child. They represent you. Those are competing interests. So an ad litem is appointed by the court, and that just goes off of a list. They have a list of attorneys that act in that role, and they appoint them as their name comes to the top of the list for the next case. And in that application process, there are certain people, like I said earlier, and some of those are listed here, that do need to be notified of that hearing. So you can either get them to sign waivers where they're saying, I know that, so-and-so has applied for guardianship of this person, and I've been supplied with a copy of the application, and you don't need to continue telling me information about it. I am good. If there are any parties that need to be served, so let's say, for example, the other parent in a divorce situation, or there are adult siblings of the child who have not signed those waivers, they all need to be served, and typically that's going to be by a constable. At that point in time, what will happen is that the ad litem is going to reach out to you as the parent to schedule an appointment for that person to either talk on the phone, do a Zoom, come in person, to meet with your child, because their job is to get to what they feel is in the best interest of your child that you're trying to get guardianship over. So many times they'll want to do that in person. They might want to talk to other siblings. They might want to talk to other family members that might be very close to them. But typically speaking, most of the people who are on those ad litem lists are individuals like myself who focus in their practice in this area. And when you have those people come in, they're very well versed in this. They are really good with, you and the family and your child. They're very aware of the situation and the type of communication that needs to be had. So typically speaking, they're relatively easy to work with. And in situations where it's pretty clear cut that that individual does need an actual guardianship placed over them, the process goes pretty smoothly. It just kind of depends on what the exact situation is. So this kind of gives you a list of, realistically, more so people who cannot act as guardian. But the easiest way to think about it in terms of kind of who gets to be guardianship first is think next of kin. If I am married, my spouse is going to be the first choice of the court. Now, that if my spouse doesn't want to be guardian, they don't have to be. Then maybe it goes to my parents or my sisters. So it kind of goes down the family line in terms of a hierarchy of who the court is going to prefer to appoint. Now, practically speaking, just because spouse is first, parents are second, siblings are third, doesn't mean that any of those people necessarily want to take on that job. So practically speaking, it's going to be who is willing and able to do the job and stepping up to apply. And have any of those people who have a higher level of right to serve not signed waivers, not been served. But anybody in that list, if let's say we've got, a family friend or a step parent trying to apply for guardianship, again, we go back. Parents have to be notified or sign waivers. Adult siblings have to be notified or sign waivers. So anyone down that line can technically serve as guardian. It's just a matter of who has preference on that.
Melissa, we have about 7 minutes left today, and I really want to spend more time on this less restrictive. I want you to hit the highlights of what might I kind of don't want to say like a slam dunk. What is a pretty definitive idea that maybe a person really should be considering guardianship? Like, for instance, if the individual's IQ is below 70 or well below 70, is that a pretty good indication that maybe they would not have capacity to understand what they were signing, like a supported decision-making agreement and things like that? Is that a fair litmus test?
I would say at that point, it's a pretty straightforward choice. Now, could there be outliers? Yeah, there can always be outliers. But generally speaking, if you're looking at an IQ, 70 below, especially significantly below 70, you are definitely going to be in that we need a guardianship range. If you go over that, it really can be questionable. And there are certainly situations where I've had clients come into my office where, they are unsure. And when I sit down and talk to their child or talk to them about their child, I can clearly state to them, you do not need a guardianship. You
Sure.
absolutely get away without it. But it's
Somebody
usually,
asked, what if they don't have the guardianship? Like, for instance, if so, in that example, and we talked about this in the beginning. So let's say a person doesn't have a guardianship, but they should. And let's say mom, dad pass away. Let's just use that example. Somebody in the chat box wanted to know, does CPS swoon in and take guardianship of the person? Does their kid become a ward of the state? Like, what happens when a guardianship should have been in place and it absolutely wasn't, and then what?
So in terms of the question of like, does the state take my child? There's kind of two realms where that question does come up a lot. And there's the actual minor child, like I have a 12-year-old child and both parents died tragically in a car accident or whatnot. That's a very different situation than I have a 23-year-old child with special needs. The state is generally speaking not going to come in and just take control over your 23-year-old adult child with special needs, because they're not even going to know that that's an issue until someone notifies them. So usually what's going to happen is that there's going to be, a grandparent, an aunt, an uncle, a family friend, whoever it might be. And if it's that dire of a situation, they're going to want to start that process to apply for guardianship. Now, CPS, excuse me, at that point, it wouldn't be CPS. It would be more of adult protective services at that point, is going to, be involved. They're going to, especially if there's a report filed, because they have an obligation to look into it if there's a neglect situation or there's a potential harm situation. But just because someone has a lower level of capacity doesn't mean that the term, they don't become a ward of the state, as people like to ask. That's not really how it works. But the state will be involved in terms of determining, okay, are there things that we do need, like an investigation, like if there was a report of something like that. But usually if you are, let's say the sibling, let's say mom and dad had been taking care of, Sarah, and she's 23, and now mom and dad were in the car accident, maybe sister Sally is there. And if mom and dad never did it and they got away with it, and that sounds worse than it means to sound, but they got away with it because they had relationships with the doctors and they were able to make things work. And now we've got the sister, and the doctors are not going to work with the sister the way that they were with mom. You're going to need to get guardianship at that point.
And when there's a family that there is nobody else. There's no other siblings. There's nobody else to step in. And in that example, if their loved one can't handle things or do things on themselves or enter into contracts, et cetera, what we've been talking about, may they need guardianship or partial guardianship in that example if there's nobody at the end of the line?
Yeah, if there's nobody in the family or close friends, at that point, you could end up in a situation where the court is appointing a professional. There are professional guardians out there, because if someone does need a guardian, there's always a possibility. And it's not necessarily that the state is the guardian, but they're going to appoint a professional to serve in that role, particularly when dealing with the assets. They're going to appoint a trust company, an attorney, a CPA as the actual guardian of that estate. The way that they work with guardian of the estate and guardian of the person is slightly different, but there are companies out there that serve as guardians of the person now too, which is a little bit newer in the area, but those are out there. So it could happen. It could definitely happen that if somebody has no one close to them, but that process is usually going to start from an emergency call being placed to Adult Protective Services.
Okay. So let's go on those less restrictive options. I know we're running out of time for today. There's lots of questions in the chat box, which are all very good. And I'm going to send those questions over to Melissa. And you guys, I'll have her contact information. I'll put that in the chat box as well. So if you wanted to reach out and go deeper on your personal question, you can certainly do that. But let's hit on this, the supported decision-making agreement, power of attorney, healthcare power of attorney.
So these can be really great tools when you have an individual who is going to need some help. So I will preface this by saying this. Every single person who has a child, when your child turns 18, all of them should have basic medical powers of attorney, financial powers of attorney, HIPAA authorizations, all of that. You should encourage your children to get in place at 18. Because the minute they turn 18, even if they are fully capable of making those decisions for themselves, if your child's in an accident, if they want your help in scheduling a doctor's appointment because they are just away at college and busy and have really enjoyed mom and dad being able to do those things for them, you're going to want to have them in place. What this really is getting at in specific regard to children who do have a kind of higher need, a special need, a disability of some sort, The biggest one here is your supported decision-making agreement. And this is why these become so helpful and so important. A lot of it comes down to medical. Your medical power of attorney does not technically have the authority to tell the doctor to do anything until the doctor says that you can't do it for yourself. Durable powers of attorney or financial powers of attorney are a little bit different. Most of the time, those are going to be durable powers of attorney that are effective the minute that they're signed, which means that if, let's say, mom and dad have durable power of attorney for, your daughter who's 19 years old, your daughter can manage her money perfectly fine, but you can too. So if she wants you to help her write bills or whatnot, you can do that even though your daughter has capacity. So someone who has the ability to sign those documents, if they have the capacity to understand essentially that I am making a contract with you and giving you the right to write checks on my account and talk to Social Security for me and pay bills and do all of those things, then you can have your child sign those documents and you'll be able to help with those things on the financial side. Supported decision making is so important because, like I said, medical, you don't have the right to make decisions. And what that supported decision making agreement actually does is it gives you the authority to get information from the hospital, doctors, school staff, employers, so that you can, like I said earlier, not necessarily make the decision for your child, but help them gather all of the information and do, the due diligence, if you will, to help your child and guide them to making the best decision. Ultimately speaking, your child gets to make the call. But for individuals who, are not quite so much of a need to have a guardianship, this can be really, really helpful. And it is a little bit of a newer thing. I will say I've had some, questioning on it with some clients and how much does this really work? But in Texas, at least, this is a legal document that has to be followed. You do need a HIPAA authorization with it, but that's going to allow the parents or whomever it is, maybe it's the grandparents, maybe it's the sibling, whoever that is, it lets you help them get the information so you can speak directly to those third parties that you otherwise would not be able to speak to.
So this document might be appropriate for those kids that are, they have issues, they're struggling a little bit here and there, but they may not have an intellectual disability. Our kids and their brains, they're not even fully formed till they're 26. So we may have kids that are high functioning, autism or ADHD, and maybe they don't have an intellectual disability. They have many deficits, many things that they're not great at. This might be a really great start, and then you may never need to change it. I mean, it might be a really, really great start. And I am a fan, and I guess Texas and the law is too, that, you can start here. And if you see that this is not enough, clearly, this is not going to work, then you can kind of up the ante and go to a partial guardianship or full guardianship. But for a person who has capacity to understand what they're signing, this is a really, really good first step, I think.
Yeah, I will be very frank with everyone in the room. When these first came out, I personally was a little reticent too. And my initial reaction to these was, I don't know how much these are actually going to help. But just like with most things when laws happen, the law gets passed, it takes a while for businesses, third parties to get accustomed to using them and being familiar with what they can and cannot do with them. I love them now. I do them with a lot of our clients, and I find them to be a really great tool because it's going to allow you that, like Allison was saying, that kind of time frame to test the waters before you go to, yeah, I'm going to go ahead and get a court to appoint me as a guardian. If you have that flexibility, if you have that kind of in between space, it can be a really great thing to try. And then if it's not sufficient, if things get worse or it's just not doing it, then you can go to do the guardianship.
For sure. And I know we had lots and lots of questions today, and maybe what we'll do, maybe we'll send over those questions to you, and maybe we'll send out a group email or something like that with answers to those big questions. I'll have Meredith connect with you on that. Thanks everybody for being here today. Reach out to Melissa directly at Texas Trust Law. And get your questions answered. Everybody's situation is a little bit different, whether it's a divorce situation or an absent parent situation or it's the end of the line. There is nobody else situation. Everybody's is a little bit different. So thank you everyone for being here today. We will send you a link to the recording as well as the slides, which will also have our upcoming webinars coming up over the next few weeks as well. So it's certainly our pleasure. And Melissa, we'll look forward to partnering with you again soon. Thank you so much for the information. Take care.
Thank you, Allison.
Bye now.